City law that capped how much landlords could charge for rental application fees was thrown out by a judge that said it conflicted with state law. I'm Tony, and this is Real Estate Investing and Landlord News. All right, so I have an interesting article for you today, and it's going over one of those laws that I talk about that tries to cap how much landlords can charge for their application fees. So a lot of the more progressive cities right now, they're trying to hit landlords hard with this because they say, hey, tenants, they're having to spend all this money for application fees and they just can't afford it, right? Which might be true. However, landlords need to be able to cover the cost that they incur when doing tenant screening, okay? Now, I don't know about what other landlords, how much it costs them, but I know for me, whenever I do a background and, credit and eviction history check on a tenant, it costs me around $40 per person. Okay, so if there's a household with 2 people in it, I have to screen both of them. It's $40 per person, so $80 total. Okay, so obviously there are costs involved with doing tenant screening, but they don't look at that sort of fact. Instead, they think that landlords are just being evil. They're just charging a whole bunch of money and there's no reason for it. So this city up in Oregon, Eugene, decided they were going to cap the amount that landlords could charge to just $10, okay? And that doesn't cover any of the costs, in my opinion. It almost makes it so that you're like, well, you know what? I am going to figure out some other way because this isn't going to work at all. But a judge fortunately figured out that, hey, you know what? There's a state law up in the state of Oregon, and this conflicts with that state law. So hopefully landlords will be able to go forward and charge what they need to charge in order to recover, the costs that they incur when they're actually doing the screening. Goodness, I hate this because in my opinion, what they're trying to do is make it so that landlords can't do tenant screening, so that we have to, basically put anyone in there who just applies, whether they have criminal history, whether they have eviction history or whatever. And, that's just not going to work for most people's business plan. And you know what a landlord is really going to do if they can't charge for that cost? It's going to be reflected in the rents. The rents are going to be much higher. So I don't know a single landlord out there anywhere who profits off of application fees. That's stupid. Okay, I don't know any landlord who's like, yeah, man, I'm going to open this up and we're going to make thousands of dollars off of these applications. No, that's garbage. That's, some kind of fake story that they're making up because no landlord makes any money off application fees, okay? Our money is made off of the rental payments, not application fees. It's idiotic to me that these politicians and these, tenants advocates believe like we were collecting some kind of pot of money off of that. What idiocy. Anyway, let's get into this article. Oh, wait, before I get into the article, go ahead, hit the like and subscribe button. Maybe leave a comment down below and let me know what you think, okay? So you, as a landlord, do you make a profit off of tenant application fees, the fees that you charge tenants in order to rent your units? Okay, I mean, maybe I'm wrong. Maybe there's some landlord somewhere and they're like, yeah, I take in 500 application fees, but then I only screen one tenant and then I pocket all the rest. That's how I make my real money. No, I highly doubt it, okay? So, if I'm right, there's not going to be any landlords who respond to this who say, yeah, I make money off of this and I don't use those fees just for the cost that I'm incurring. So anyway, let's get into this article. This article is coming from theregisterguard.com and it says, Courts, Judge, Eugene's $10 cap on rental application screening fees conflicts with state law. Let's get into it. Eugene's limit on rental application screening fees conflicts with state law, according to a judge's ruling issued Tuesday. Lane County Circuit Court Judge Aaron Finnerty wrote enforcement of the $10 cap ultimately defeats the purpose of the applicant screening charge, as a landlord cannot recoup its average actual costs as required under the Oregon Residential Landlord and Tenant Act. So yeah, under the Oregon Residential Landlord and Tenant Act, the landlord should be able to recoup its average actual costs Okay, so keep in mind that every landlord is going to have different expenses. I use a different screening service than some other landlords. Maybe a landlord who does, hundreds of screenings every year gets a better deal on screening than I would. Maybe the landlord who has a staff member on hand has to pay that staff member is going to have a higher cost, to call up employers, to call up, former landlords, etc., and check the references. So, than a guy who is managing his own properties. But regardless, right, a landlord should have the individual ability to decide, hey, this is how much this is costing me, not the government. Okay, when the government decides how much something costs, you see what the problem is. They never think it's enough. Okay, they never give you enough. So the government will sit here and they'll be like, well, it should only be $10 to screen the tenants, right? But they didn't go and do a survey of landlords to see how much actual expenses were. They didn't call up the background investigation companies to see how much a background screening was. They just pulled that number out of the back of a hat or something, I don't know where they got that number, other than, well, this is all tenants really want to pay. Well, just because that's all tenants want to pay doesn't mean that it's the actual cost. And this judge was absolutely right in saying it defeats the purpose of what's written into the Residential Landlord and Tenant Act for the state. Eugene officials passed the cap on application and screening fees in July as part of a first slate of renter protections, which the city council is considering in 3 phases. Thorin Property and Jennings Group sued in November, describing the limit as arbitrary and arguing it violates state law. They said application screening typically costs 4 to 5 times the $10 cap. And they're absolutely right, okay? Like I said, it costs money. And, none of this stuff is free. We're sitting here, we're expected to eat these losses. And yeah, we are going to have to screen more than one tenant for every single unit that we're renting out. Okay, so there's going to be tenants who get screened and then don't get the unit. Okay, I personally have experienced this. I've experienced this because every single rental unit that I rent out, I usually screen at least 3 tenants. So you're telling me that I can't charge application fees to do my screening? That's ridiculous. The lawsuit did not address 4 other protections passed in the first phase. Finnerty ruled in the property management company's favor, writing state law allowing landlords to charge for the actual cost of the background checks supersedes the city's ordinance. Darren Stone, the principal at Jennings Group, said landlords hope the council will invite them to the table in a meaningful way to help craft renter protections that work for tenants and landlords. Participation through public comment at council meetings is insufficient, Stone said in an email statement. Participating through litigation is a poor use of everyone's resources and does nothing to address the challenges renters face in our community. Yeah, but you know what? I see this all the time. Basically, the only way that landlords can get their message out to these politicians, to these bureaucrats, is by suing, okay? The only way that we can get our side of the story out there is by saying, hey, we're going to take our money from you through the legal system because you screwed us over. They don't want us at the table. They don't, because we speak with logic and common sense. We can bring them actual numbers of what our costs actually are. We can tell them the reasons that we do the things we do, and they don't want to hear it, okay? They want to assume the worst about us. They want to assume that we are bad people and that we're trying to screw the tenants over. And you know what, the problem, and this is one of my biggest gripes with people is, right, they get so set in their ways, right? They get so set in their ways, they don't want to hear a conflicting argument, from the other side. They think, well, my way is right. I don't want to hear what the other side even has to say. And I don't give a darn about fairness. I don't give a darn about, the laws that are already in place in the state. I don't give a darn about the Constitution. And we're just going to pass it anyway because it makes me feel good. Well, you see what happens, right? You got judges throwing their garbage out. Thank goodness the judge had some common sense, because otherwise landlords would still be suffering under this ridiculous law. A spokesperson for Eugene said the city was reviewing Finnerty's decision. The Springfield Eugene Tenant Association said more than half of renters in Eugene spent more than half their money on rent. Expensive application fees exacerbate that and disproportionately harm renters of blah, 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 blah. I'm not even going to read that part, right? You know what? The tenant association is going to say what they're going to say because in their opinion, right, they want cheap or free rent forever. They want impossible for landlords to be able to evict them. They want no fees. They want, basically they want the government or the landlord in this case to take care of these people, and they face no consequences for not paying rent, no consequences for breaking the terms of their leases. And to me that's dumb. Okay, we have to live in reality. We have to have property rights for the people who own the properties. Tenants have rules that they agreed to in the leases that they signed. And you know what? I'm sick of the government stepping in and saying, oh, no, we know better than the landlord, the people who actually run the property, what something costs.